Lord Acton says, power tends to corrupt and absolute power corrupts absolutely. While James Madison says, concentration of power is tyranny. Hello friends, welcome to my channel, Indus Educare. And in this video, we are going to discuss about administrative law. So let's begin with introduction and definitions of administrative law. Administrative law is a branch of public law. It deals with the relationship of individuals with the government. It determines the organization and power structure of administrative and quasi-judicial authorities to enforce the law. It is primarily concerned with official actions and procedures and puts in the place a control mechanism by which administrative agencies stay within bounds. However, administrative law is not a codified law. It is a judge-made law which evolved over time. Now, let's see some definitions of administrative law. According to Ivor Jennings, administrative law is relating to the administration which helps in the determination of organization, powers, and duties of the administrative authorities. According to Casey Davis, administrative law is a law which is related to powers and procedure of administrative agencies, including especially the law related to judicial review of administrative actions. According to Professor H.W.R. Wade, administrative law is the law which controls the powers of the government. According to Dicey, administrative law denotes that part of the nation's legal system which determines the legal status and liabilities of all state offices, which defines the rights and liabilities of private individuals in their dealing with their public officials, and which specifies the procedure by which these rights and liabilities are enforced. And finally, according to Indian Law Institute, administrative law is law relating to the power of administration. It also includes the procedure of how to exercise the powers, limits of those powers, the way in which the powers are kept in those limits, followed by the officials, and the remedies available to the public when the rights have encroached. Now, let's see the nature of administrative law. Administrative law is divided into legislative, judicial, and purely executive authorities. Administrative law is the branch of public law which defines the relation between individuals and state. It is not a law in true sense like other laws such as property law or labor law. It is also not like private law which deals with the relations of individual inter se. It is law to administer the administrative authorities and check them from making any arbitrary decisions. Administrative law deals with the organization, powers, and duties of the administrative authorities and also the procedure followed by the officials while exercising the powers. Administrative law is limited to the law which limits the power of administrative authorities while exercising the powers. It also provides remedies in the favor of public when the rights of the public encroached. In India, administrative law is almost a judge-made law. Thus, it suffers from more facilities and benefits because of judicial lawmaking. Judiciary interprets the law according to the need of time and issues guidelines for such. It affects administrative law and makes it more strong and beneficial. It is a branch of the Constitution that regulates all three branches, that is, legislative, executive, and judiciary. In the same way, administrative regulates all the administrative authorities and protects them from corrupt practices. Let's see the scope of administrative law. Scope means an area of study or the variety of subjects that are being discussed or considered. As administrative law is almost a judgment law, so it changes according to the societal needs, but in the guidance of the basic principles, so the scope of this law is wider in comparison to the other laws. Administrative law determines the powers and duties of the organization and the administrative authorities. The concept of the administrative law is founded on the following. The first, principle of natural justice and for rule making. Second, notion of the rule of law. Third, law conferred power to administration as per Article 13 of the Indian Constitution. The fourth is accountability of powers. No power is absolute or uncontrolled. The fifth is there should be a reasonable restriction on the regulations of such powers. Sixth, the power of the court to issue writs. And the last, seventh, is opinions of public and mass media. It is important to see the reasons for the growth of administrative law in India. In India, since the Mauryan and Gupta age, there has been the administration of legislation, rule adjudication, and the related provisions. The following are the reasons for the growth of administrative law in India. The first is concept of welfare state. We can see the evolution of welfare state concept. The concept was developed during the 10th and 20th century. According to this concept, the state administration is to achieve maximum welfare of the masses. The second is inadequate judicial system. Judiciary was slow, costly, unexpected, complex, and formalistic in nature. Overburdening of judicial system due to which speedy disposal was not possible and also resulted in strikes and lockouts in disputes between employers and employees. Third, inadequate legislative. The legislature has no time to legislate upon the day-to-day ever-changing needs of the society. Detailed procedure made by the legislature were found to be defective and inadequate. Next, scope of experimentation. As the administrative law is not codified law, there is enough scope of modification. Fifth, increasing demand from people. There was an increase in the demand from the people because merely defining the rights of the citizens was not sufficient, but state needs to solve problems as well. Sixth is to take preventive measures. Administrative authorities can take preventive measures like licensing, rate fixing, etc. They can also take effective measures for the enforcement of preventive measures like enforcement of suspension, revocation, or cancellation of license. And the last, seven, increasing population. Increasing the population creates a burden upon the legislative processes to implement various laws for various needs of growing population. The sources of administrative law in India are Constitution of India, acts or statutes, ordinances, notifications, circulars, etc., and judicial decisions. Let's see one by one. Constitution of India. It is the primary source of administrative law. Article 73 of the Constitution provides that the executive powers of the Union shall extend to matters with respect to which the Parliament has power to make laws. Similar powers are provided to states under Article 62. The second is Acts or Statutes. Acts passed by the central and state governments for the maintenance of peace and order, tax collection, economic and social growth, empower the administrative organs to carry on various tasks necessary for it. These acts list the responsibilities of the administration, limit their power in certain respects, and provide for grievance redressal mechanism for the people affected by the administrative action. And the third is Ordinances, administrative directions, notifications, and circulars. Ordinances are issued when there are unforeseen developments and the legislature is not in session and therefore cannot make laws. The ordinances allows the administration to take necessary steps to deal with such developments. And the last is judicial decisions. Judiciary is the final arbiter in case of any dispute between various wings of government or between the citizen and the administration. The courts, through their various decisions on the exercise of power by the administration, the liability of the government in case of breach of contract or tortious acts of government servants, lay down administrative law which guide their future conduct. Now, let's see about laissez-faire. Laissez-faire is a French phrase which means allowed to do. It is the policy of minimum governmental interference in the economic affairs of individuals and society. Transition of doctrine of laissez-faire to welfare state with special reference to India. Administrative law is recognized as the most outstanding legal development of the 20th century. The 19th century was characterized by the welfare state, wherein there was a minimum government control, free enterprise, contractual freedom, etc. The state played a negative role. It was primarily a police state which helped in the maintenance of law and order, protecting the nation from external aggression, dispensing justice to its citizens, and collecting taxes for financing such activities. However, in the 20th century, the evils of the system were realized. Due to contractual freedom and freedom of enterprise, there was unequal distribution of wealth. This led to several socialist movements, especially ones in which the grievances of labor was sufficed. Need was felt that the state shall be more than a police state. This led to the establishment of the social welfare state. Before independence, India was essentially a police state as the British were more interested in furthering their own interests rather than working for the welfare of the people. The concept of social welfare was taken up immediately after independence, especially after the adoption of the Constitution. The preamble to the Constitution states that India shall be a socialist, secular, democratic republic and must provide justice, equality, rights, freedom, etc. to all. Also, a right to free and compulsory education for children up to 14 years is now a fundamental right. Droit administrative. Let's see the meaning of droit administrative. Droit administrative is the French administrative legal system. It means a body of rules which determines the organization, power, and duties of the public administration and regulates the relation of the administration with the citizens of the country. Droit administrative does not represent the rules and principles enacted by the parliament. In case of India, we see that the system is the representation of the rules and principles enacted by the parliament or legislature. Historical background of Droit administrative. Napoleon Bonaparte was the founder of the Droit administrative. It was he who established the Council d'État, that is, Council of State, and passed on the ordinance. Droit administrative is based on some rules and principles. Let's see those rules and principles. The first is rules of droit administrative. Rules relating to the administrative officials and authorities. These are related to the appointment and dismissal, status, salaries, duties, etc. of the administrative officials. The second is rules dealing with the operation of public services to meet needs of the citizens. These services may be operated either wholly by public officials or under the supervision of other agencies to provide the public utility services. Rules dealing with the administrative adjudication. This deals with the concept that if There is any adjudication done to a private citizen by the administrative authority, it could be decided by the administrative courts. Here, Court d'Etat is the highest administrative authority. Now, the principles of droit administrative. The first principle is that the power of the administration to act suo motu, that is, on its own, and to impose its decisions directly on the subjects, to make them obey it as a duty. The second principle is the power of the administration to take decisions and execute them suo motu. It may be exercised only within the ambit of law. It prevents the arbitrariness of the individual liberties against any arbitrariness. And the third and the last principle is the existence of a specialized administrative jurisdiction. Now, let's see the criticism of Detroit administrative. It is criticized that there are special privileges for the government officials and other persons. All the persons, irrespective of the statute, should be subject to the ordinary courts only. Everyone should be governed by the laws passed by the ordinary legislative organ of the state, which is completely missing in the administrative courts. It violates the modern provisions of the rule of law and Article 14, that is, equality in the eyes of the law. Now, about administrative tribunals. Administrative tribunals are agencies created by specific enactments to adjudicate upon controversies that may arise in the course of implementation of the substantive provisions of the relative enactments. Administrative tribunals solely quasi-judicial functions. The tribunals are generally given to the power of civil court, enjoyable under the Code of Civil Procedure in the matters of summoning witness, compulsory production and discovery and documents, receiving of evidence on the oath and on affidavit, issuing commissions, etc. Let's see the characteristics of administrative tribunals. Administrative tribunals are established by the executive under the provisions of statute. They are required to act judicially. They perform quasi-judicial functions. They are independent and imperial and work without being influenced by the government. They have the powers of civil courts in certain matters, and their proceedings by the considered to be judicial proceedings. They are required to follow the principles of natural justice in receiving cases. They are not bound to follow the technical rules of the procedure and evidence prescribed by the Civil Procedure Code and Evidence Act. They are not courts in the proper sense of terms. This picture explains the difference between administrative tribunal and court. Examples of administrative tribunal are Industrial Tribunal, Railway Rates Tribunal, Copyright Board, Income Tax Appellate Tribunal, Claim Tribunal, Election Tribunal, etc. Now let's see the relationship between constitutional and administrative law in India. First of all, let's see the meaning of constitutional law and administrative law. The constitutional law is a body of law which defines the role, powers and structure of different entities within a state, namely the executive, the parliament or legislature and the judiciary, as well as the basic rights of citizens. And in federal countries such as the United States, India and Canada, the relationship between the central government and state, provincial or territorial governments. While the administrative law deals with the decision-making of such administrative units of governments as tribunals, boards, or commissions that are part of a national regulatory scheme in such areas as police law, international trade, manufacturing, the environment, taxation, broadcasting, immigration, and transport. Administrative law deals with the organizations, functions, powers, and duties of administrative authorities, while constitutional law deals with the general principles relating to the organization and powers of the various organs of the state and their mutual relationships and relationship of these organs with the individuals. Administrative law lays emphasis on public need, while constitutional law deals with the rights. The source of administrative law may be statutes, statutory instruments, precedents, and customs. The sources of constitutional law is Constitution itself. Administrative law deals with the details of those functions, while constitutional law deals with the structure and the broader rules which regulates the functions. Now, let's see the concept of separation of powers. The concept of separation of powers is the rudimentary element for the governance of a democratic country. This principle corroborates fairness, impartiality, and uprightness in the working of government. Although it is not followed in its strict sense yet, most of the democratic countries have adopted its diluted version under their respective constitutions. So, what is meant by separation of powers? The concept of separation of powers refers to a system of government in which the powers are divided among the multiple branches of the government, each branch controlling different facets of government. In India, the constitution does make the provisions for a reasonable separation of functions and powers between the three organs of government. These three organs are a legislature, executive, and judiciary. Legislature. The chief function of the legislature is to enact laws. It is the basis for the functioning of the other two organs, the executive and the judiciary. It is also sometimes accorded the first place among the three organs because until and unless laws are enacted, there can be no implementation and application of laws. Executive. The executive is the organ that implements the laws enacted by the legislature and enforces the will of the state. It is the administrative head of the government. Ministers, including the prime minister or chief ministers, and president or governors, form part of the executive. Judiciary. The judiciary is that branch of the government that interprets the law, settles disputes, and administers justice to all citizens. The judiciary is considered the watchdog of democracy and also the guardian of the Constitution. It comprises of the Supreme Court, the High Courts, district, and other subordinate courts. Now, let's see the significance of the doctrine of separation of powers. This principle ensures that autocracy does not creep into a democratic system. It protects citizens from arbitrary rule. Hence, the importance of the doctrine separation of powers can be summed up as follows. It keeps away autocracy, safeguards individual liberty, helps create an efficient administration, judiciary's independence is maintained, and prevents the legislature from enacting arbitrary or unconstitutional laws. Let's see some examples of this doctrine. Article 50. This article puts an obligation over the state to separate the judiciary from the executive. But since this falls under the directive principles of state policy, it is not enforceable. Articles 53 and 154. It provides that the executive power of the union and the state shall be vested with the president and the governor, and they enjoy immunity from civil and criminal liability. These provide that the legislatures cannot discuss the conduct of a judge of the Supreme Court or High Court. They can do so only in case of impeachment. Article 123. The President, being the executive head of the country, is empowered to exercise legislative powers in certain conditions. Article 361. The President and Governors enjoy immunity from court proceedings. They shall not be answerable to any court for the exercise and performance of the powers and duties of his office. And finally, let's see the conclusion of the doctrine of separation of powers. The doctrine of separation of powers in the strict sense is undesirable and unpractical, and therefore till now it has not been fully accepted in any of the country. But this does not mean that the doctrine has no relevance in the world of today. The logic behind this doctrine is still valid. A rule of law. Rule of law is a classical principle of administrative law. As a matter of fact, this principle was one of the principles that acted as impediment to development of administrative law principles. The rule of law is now an important part of modern administrative law. Dicey defined the rule of law as the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power and excludes the existence of prerogatives or even wide discretionary power on the part of government. There are some principles of rule of law. In 1885, Professor A.V. Dicey developed this concept of Coke and propounded three principles or postulates of the rule of law in his classic book Law and the Constitution. According to Professor A.V. Dicey, for achieving supremacy of law, three principles or postulates must be followed, which are as follows. First, supremacy of law. Second, equality before law. And the third is predominance of legal spirit. Let's hear these principles one by one. The first is supremacy of law. As per the first principle, rule of law refers to the lacking of arbitrariness or wide discretionary power. In order to understand it simply, every man should be governed by law. There must be absence of wide discretionary powers on the rulers so that they cannot make their own laws but must be governed according to the established laws. The second is equality before law. According to the second principle of Dicey, equality before law and equal subjection of all classes to the ordinary law of land to be administered by the ordinary law courts, and this principle emphasizes everyone, which included government as well, irrespective of their position or rank. The third is predominance of legal spirit. According to the third principle of Dicey, general principles of the Indian Constitution are the results of decisions of Indian Judiciary which determine to file rights of private persons in particular cases. According to him, citizens are being guaranteed these certain rights such as a right to personal liberty and freedom from arrest by many constitutions of the states. Let's see rule of law under Indian Constitution. In order to develop Indian democracy, rule of law has played a great role. At the time of framing Constitution, the framers had two options, that is, USA and England. Some of the provisions were adopted from USA and some of them were adopted from England. Rule of law was adopted from England by our constitutional fathers, and many provisions were incorporated in the Indian Constitution. Indian constitution is considered to be supreme and no one is above the Indian constitution. Rule of law is also given impliedly in the preamble and such concept is enshrined in the part 3 of the Indian constitution. Finally, the conclusion on the rule of law. From the above mentioned discussion, it can be concluded that supremacy of law is the aim. Rule of law is the best tool to achieve the aim. Some of the efforts are also taken by the court where the rule of law is linked with human rights of the people. In the Indian society, the rule of law has not achieved the intended results. A few examples where rule of law was upheld by our judiciary and ensured justice can be clearly seen in the creation of new avenues seeking remedies for human rights violations by filing of PIL pleas. Thank you friends and good luck.